Thank you, Norma. As Norma said, I'm Tracy Willenborg. I'm with Taylor Law Offices. I'm a partner there, having been there for approximately 18 years. She also advised that I'm the city attorney for the city of Effingham. I also serve as a municipal attorney for over 20 other municipal corporations. I'm going to start tonight with the Illinois Open Meetings Act, which you'll see we're going to shorten it to OMA. In the back, I brought someone to click through the slides. I'm sure he's going to do an amazing job. Thank you. He moved to the next slide. So as an attorney, we always have to put disclaimers in presentations we make because we just can't help ourselves. So I'm disclaiming certain things, and I'll give you an opportunity to read that really quickly. And next slide. So, purpose of OMA, the Open Meetings Act. The Illinois Open Meetings Act is designed to ensure that the public has access to information about government and its decision-making process. The public policy of the state is that people have the right to be informed as to conduct of the business of the municipal body, and to ensure that the actions of public bodies be taken openly and that their deliberations be conducted openly. That's the intent of the act. It's also the public policy of the state that citizens should be given advance notice of and the right to attend all meetings at which any business of the public body is discussed or acted upon in any way. In limited circumstances, there are exceptions. And really quickly, I want to provide a differentiation between the Freedom of Information Act, which I'll be talking about later, and the Open Meetings Act. Freedom of Information Act applies when a member of the public is seeking access to public records. The OMA is intended to ensure that the actions of public bodies are conducted in open through public meetings, and that the public is able to observe the deliberations between those actions. So that's, in a nutshell, the differentiation. There are, I could be here for hours talking about Open Meetings Act and hours talking about the Freedom of Information Act. So I'm going to try to provide a summary of both things. I feel like I'm going to take off my shoes so that I can actually get closer to this mic without hunching over. Like I said, I could talk for hours about both of these acts and the requirements because they're chock full of requirements on governmental bodies and discussions as far as rights and obligations. But I'm going to summarize them for the purpose of this meeting. The general requirements of an Open Meetings Act requires that meetings of public bodies be open to the public except in certain specific limited situations where the law authorizes the public body to close a meeting. The act also provides that the public must be given advance notice of the time, place, and subject matter of the meetings of public bodies. It establishes requirements for recording of meetings, as well as requirements for keeping minutes of meetings. The OMA also establishes annual training and other training requirements for certain members of the public body. So, as mentioned, next slide. As mentioned, the Open Meetings Act provides that all meetings of public bodies shall be open to the public. Considerations when OMA meeting requirements apply, two things that we need to look at is what is considered a public body and what constitutes a meeting under the OMA. First, I'll address what public bodies are covered by the OMA. I give up. The term public bodies is specifically defined in the Open Meetings Act to include all legislative, executive, administrative, or advisory bodies of the state, counties, townships, cities, villages, and incorporated towns, school districts, and any other municipal corporations. Public bodies also includes any committee, subcommittee, or subsidiary body of the foregoing, including whether or not they're supported in whole or part by tax revenue or expend tax revenue. Examples of these other municipal corporations are like park district boards, special districts like fire protection, water districts, zoning board of appeals, pension boards, plan commissions. Now, what's interesting is what is not considered a public body under the Open Meetings Act. And whenever you look at the definition of public body, right in the middle, kind of hidden, it says a public body does not include the Illinois General Assembly and committees or commissions thereof. So the Illinois General Assembly is not a public body required to comply with the Open Meetings Act. There's also in the Act other boards and commissions that are specifically excluded. Now that we know what a public body is, the next thing we need to consider is what is a meeting? Under the OMA, there are 3 key elements to the definition of a meeting. Generally, a meeting is defined as a gathering by a majority of a quorum of the members of a public body for the purpose of discussing public business. And I'm going to briefly discuss each of these 3 key elements. First, what is a gathering? Under the OMA, a meeting is any gathering. This is not just in person. It can be by video or audio conference, telephone call, electronic communications, or other means of contemporaneous interactive communication. That's in the definition. Now, for instance, and this could be a long conversation about what this entails, but when you think of it, now that we have all these electronic means and social media programs, you have to be cognizant of that as a public body on commenting on those. If a majority of a quorum comments in a contemporaneous interactive manner on social media, including Facebook, Snapchat, Twitter, whatever comes up in the next how many years, because it's ever changing, that can be and raise communication issues under the OMA. That could be considered of a meeting, and if you don't open it to the public, that could be a violation. So we have to be cognizant of corresponding and electronic avenues, especially with emails. A lot of communication goes through emails. As a member of a public body, never, ever, ever reply all. You just violated the Open Meetings Act if you replied all to a majority of a quorum of that public body. Never, ever. Turn that feature off. Now, the next factor, what constitutes a majority of a quorum? This sounds complicated, but quorum just means the number of members of a body or a committee required to take formal action, which is always a majority of the entire membership of that body or committee. So for a 9-member body, a quorum is 5 members, and a majority of those 5 members is 3 members. Therefore, a 9-member body can have a meeting that must comply with the Open Meetings Act when 3 or more members are present. For an 11-member body, a quorum is 6 members, and a majority of a quorum is 4 members. Thus, an 11-member body can have a meeting when 4 or more members are present. You can do this analysis for any size of public body, and I put a chart together to sort of show. Now, there is one exception for a rule, that the math doesn't necessarily work because there's an exception. For a 5-member body, the full quorum of 3 or more members is required for a meeting. There isn't a special rule for 3 members bodies. Therefore, if 2 people get together and talk about business, that's a violation of the Open Meetings Act. And that leads me to the next. The third factor, a gathering must be held for the purpose of discussing public business in order to be a meeting. The purpose requirement means that social and other ceremonial or charitable gatherings held for purposes unrelated to conducting public business generally are not covered by the Open Meetings Act. However, you have to be cognizant that if you're at a social event or a charitable event or at like the chamber gala, a majority of a quorum of your body, if you're at there, you must keep the communication purely social and personal. You can never bring it to topic of public business. To do so would be a violation of the Open Meetings Act. Now, there are exceptions to open meetings requirements. So when can a meeting be closed? The OMA authorizes a public body can close a meeting to the public only when certain limited topics are considered. And those topics are addressed in the exemptions found in the Act. Found either in the Open Meetings Act or in another state statute which specifically authorizes closure. If a public body is dealing with one of these exemptions, it may hold a closed meeting or session. Now, the Open Meetings Act specifically provides that the exceptions are in derogation of the requirement that public bodies meet in open, and therefore the exceptions are to be strictly construed, extending only to subjects clearly within their scope. Now, the other thing is, while the exceptions authorize a public body to go into closed session, it does not require a public body to go into closed session when they discuss those topics. Common closed session topics authorized under the OMA, and there's over 30 of them under the OMA as well. And in addition, like I said, there's other state statutes that specifically authorize an exception. But common ones that I normally see public bodies going into closed session for are personnel, appointment, employment, compensation, discipline, things like that. Collective negotiating matters or deliberations. When the municipal corporation wants to purchase or lease real estate, or when the municipal corporation wants to sell or lease real estate to a third party. Pending or probable litigation against, affecting, or on behalf of the public body. Now, it can't just be someone said, I'm going to sue you. It actually has to be pending or very probable to go into a closed session. In order to go into closed session, how can a public body do that? If a public body wants to hold a closed session, the public body must first meet in a properly noticed open session meeting. Then, while in open session, which is open to the public, they must vote to close the meeting by a majority vote of the quorum present, and the Act requires the public body must cite the specific exemption in the Open Meetings Act that applies and allows the closure of the meeting and record that exemption in the minutes. And some other miscellaneous issues that I think are important is a public body cannot take final action while they're in closed session. If they want to take action on an item that's discussed in closed session, they must come out of closed session back into open session, which is open to the public, before they can take any final action on an item discussed during the closed session. Furthermore, during the closed session, the public body must make a verbatim record by audio or video of any closed session. They also must take minutes of the meeting. Semi-annually, the Act requires semi-annually that the public body must meet to review the minutes of any closed session that occurred and determine whether the minutes of those sessions need to remain confidential. If the public body determines that those minutes or portions thereof are no longer necessary to remain confidential, it must make the minutes available to the public. As I said, one of the other requirements, now that we talked about open meeting requirement and what qualifies as an exemption to the open meeting requirements, we're going to go into the notice requirements under the Open Meetings Act. Public notice must be given for all meetings, whether they're open or whether you intend as a public body to immediately go into closed session. You must still give notice. The right to attend meetings wouldn't be meaningful if notice to the public weren't given. To address this issue, the law requires public bodies to give notice to the public of its meetings. Different notice requirements are required for different types of meetings. For regular meetings, at the beginning of each calendar or fiscal year, each public body must give the public notice of the schedule that they're going to have of regular meetings for the year, including the dates, times, and places of the meetings. A public body must also post an agenda for each regular meeting at its principal office, at the location where the meeting is held, if it's different places, and if the public body operates a website by its own full-time staff, it must post its agenda on its website. All of these agendas must be posted at least 48 hours in advance. A public body may also hold a special meeting, which is different than regular, not one of the regularly scheduled meetings. In that event, the public body must also post notice at least 48 hours in advance. This notice must also include the agenda for the special meeting at least 48 hours in advance. And furthermore, there's also a mechanism to have emergency meetings for public bodies. And the notice requirements for an emergency meeting, which must be a bona fide emergency, is that the public body must give notice as soon as practicable, but in any event, they must give notice prior to holding the meeting to any news media which has filed an annual request for notice. I think you're a slide short. Go forward, please. All right. One more. Okay. Now, what's an agenda? An agenda is a list of items the public body will discuss and or act upon during a meeting. An agenda can be changed, but any revisions to an agenda must still comply with the notice requirements. That means a public body cannot change the agenda less than 48 hours before a regular or special meeting. And while a public body can discuss items that are not on the agenda of a regular meeting, the public body cannot take action or make any decision with regard to items or topics not on the agenda of a regular meeting. At special or emergency meetings, however, a public body cannot even discuss items or topics not on the agenda. One of the other things that I want to talk about, and I'm going to have to shorten this portion. Go back, please. I'm going to have to shorten this portion, is rights to public comment. The Open Meetings Act requires that public bodies give members of the public an opportunity to speak at a public meeting. Therefore, I always recommend to the public bodies I represent that a public comment section be included as an item on an agenda as to ensure compliance with the provisions of this act. Public bodies are authorized to adopt reasonable rules and regulations regarding this section, public comment, but they must be reasonable. The OMA also has record-keeping requirements in it. Oh, you're on the right one. I'm sorry. Clayton, you're doing a great job. So all public bodies must keep written minutes of open meetings and make them available to the public for inspection. If a public body has a website that it maintains with its own full-time staff, it must post the minutes on the website within 7 calendar days after the minutes are approved by the public body. Typically, minutes are approved at the next board meeting, so 7 days after approval. The Act requires that minutes must include the date, time, and place of the meeting, a list of members present and absent, whether they attended in person, by phone, or by video. Side note, I did not get in just because I was limited on time. The remote attendance options that are contained within the OMA, if you guys have any questions on that, especially during the COVID, the special exceptions, let me know. I can answer some questions, but I did limit my presentation and did not include that. So the minutes have to include how they attended, a summary of the discussion of all matters proposed, deliberated, decided, and a record of any votes taken. It's important to note that all public bodies, including subsidiary bodies and committees and subcommittees, are also required to take minutes of their meetings. Now, for closed meetings, there's more requirements. A public body must make a verbatim record by audio or video of any closed session and take minutes of the meeting. As I said, semi-annually, the public body has to meet to review to see if they can be released. Another requirement of the OMA is training requirements for members of the public body. Excuse me. And there's different training requirements depending on who you are. Each public body under the OMA must designate at least one or more Open Meetings Act officers. And that designated officer or officers must complete annual OMA training. Anytime a public body designates a new officer, the officer must complete the training within 30 days of designation. There's also training requirements for all other members of the public body. So members of the city council, trustees of village board, trustees of library boards, they all must complete OMA training within 90 days of either taking an oath of office, if you're required to take an oath to assume your duties, or otherwise assumes responsibilities as a member of the public body if you're not required to take an oath. So you have 90 days. Get it done. And while most public bodies are required to complete the training programs which was created specifically by the Attorney General, which you can do online, members of certain public bodies are statutory authorized to complete alternative training programs, and those are contained specifically in different paragraphs of the Open Meetings Act, but those include like park districts, drainage districts, school boards, fire protection districts. If you want more information on those alternative training programs, let me know and I'll help you consult the specific section. So this concludes my Open Meetings Act presentation, and I was also roped into giving the next presentation. I'm going to give them a second to switch over real quick. Thank goodness I don't worry about getting my feet dirty because I don't have shoes on right now. That would be fine. Norma, I can't see anyone, so. No, we can talk personally, and if you are less than a majority of a quorum, you can meet. So for instance, if you're a 5-member board and 3 people constitute a majority of a quorum, 2 board members can get together to talk about public business, but 3 cannot. So anything less than a majority of a quorum can still get together and talk about public business, but once you get to the majority of a quorum, you cannot. Does that help? Yes. And we can always meet socially. So if you want to have a party and invite me and the rest of your board, as long, you have to invite me, but hopefully you have snacks, because I love snacks. As long as you don't turn it to public business, you can always get together. Does anybody else? I'm sorry, I look kind of weird, but I can't really see you unless I do this because the light is very bright and nice. Any other questions?